Hi, I'm Ed Alexander, attorney and founder with Alexander Abramson, a business law firm. Recently, we had a question about co-branding in the office. And I always find it interesting that oftentimes we'll find that old relationships have new names and therefore look new. But co-branding, really all it is a strategic alliance. And it's a strategic alliance between two companies to basically benefit the two companies. And it can take multiple flavors, right? So one is that the two companies can come together, they can create a new product that they co-brand together, or one company can market the product of another company, or they can share a common logo, or maybe there's a specialized product or something along those lines. An example would be GoPro and Red Bull, right? So they market their products together because they both are looking to appeal to the same market segment, active young people, etc. And so when you're doing this, the key is to have a written strategic alliance agreement. Now, the reason it needs to be written is because in the absence of a written agreement like that, one party could claim that it's a partnership between the various entities. There are lots of bad things that come along with partnership, notably that both parties would be liable for debts and obligations, but more importantly, that the parties then would also have fiduciary duties to one another. We don't want to have that. And so we want to be very specific that it's not a partnership. The second is we want to be sure about what is the ownership of the intellectual property. So if we're developing a co-branded product, if we're developing a new logo, how is that going to be owned? What is the relationship after the time period begins? Do we terminate that? Is either party able to use that? What happens with it? And so really thinking through the steps in this process is very important because we want those expectations and arrangements to make their way into the actual contract itself. Another provision that's really important is auditing. So if one of the strategic alliance parties is collecting all the revenue and then paying the other party, we want to be sure, right, trust but verify, we want to be sure that we're getting the right amount of money. That's not to say that there would necessarily be an intentional failure to do so, but there could be innocent mistakes. And so it warrants that there have an audit provision that allows one party to audit the records of the other party as concerns that strategic relationship that they have.